Hi everybody, Jennifer Schaus here. We're coming to you live from Washington, D.C. today, and thanks for joining us in our webinar series covering the DFARS, otherwise known as the Defense Federal Acquisition Regulation Supplement. Our webinars are every Wednesday and Friday at noon Eastern, unless there's a federal holiday or anything that conflicts, and all of our webinars are complimentary and recorded. You can find all of our recordings over on our YouTube channel, along with 700 and I think we're up to 750 plus other government contracting content. And the PowerPoints are posted over on slideshare.net. You can log into SlideShare with your LinkedIn credentials or any personal email address. Again, those are all complimentary, and you can find the 700 plus PowerPoints that correspond to the webinars. If you're interested in sponsoring or advertising a webinar or the series, you can send us an email to the hello@jenniferschaus.com. The way to register for the DFARS, in case you didn't register this way over on our website, just navigate to the section called the DFARS. And you'll notice on the left-hand side, we actually covered the DFARS 4 years ago. So you've got historical recordings there. Keep in mind, they are just that, historical, and the DFARS has a heartbeat. So there could be some changes, or there were some changes between 2021 and 2025 and currently happening as well. So all of the recordings will be posted there again on our website on the right-hand side. And if it's something that we've yet to cover, you'll be able to register. A little bit about us. We do provide services for government contractors based in downtown DC, not far from our speakers today, with a primary focus on helping companies get onto the GSA schedule, VA schedule, and other contract vehicles. And on that note, some other services that we do provide for government contractors include advertising in our newsletter, events, and more. The piece on GSA schedules where we focus, I'd like to bring your attention to the executive order from March 20th that focuses on consolidating procurement through the GSA schedule. So if you need help either modifying your contract, audits, renewals, getting onto the schedule, making any modifications, please send us an email, we can assist. A little bit about the statistics on our newsletter. We do reach over 38,000 subscribers, most of which are government contractors, and then some of the statistics that go alongside that. Okay, we want to thank our in-kind sponsors, our friends over at GovEvents. That's the premier platform for posting events and content related to government contracting. You can find all of our events posted on govevents.com as well as the recordings. Fairfax County Economic Development Authority has an online calendar for events and webinars that are happening in the local area. You can find all of our events and webinars on the Fairfax County calendar site. Also, we want to thank Tom Johnson and his crew over at Set Aside Alert. That's the go-to publication for finding opportunities for small women-owned, veteran-owned, hub zone, and 8A firms. Visit setasidealert.com for more information. We want to thank our friends at the Virginia Apex Accelerator. That's a trusted resource and DLA-funded organization. They provide local training, counseling, and mentoring for aspiring government contractors, as well as matchmaking events. If you want to sell to state, local, or federal government, please contact your local Apex Accelerator. Please visit the links on your screen to review the training calendar, locate free resources, and schedule an appointment with a Virginia Apex Accelerator counselor today. Okay, we want to thank our paid sponsors. Our paid sponsors are what allow us to make this webinar series complimentary. So we want to thank BidSpeed. BidSpeed is the platform that allows users to search public sector opportunities at federal, state, and the local level. Users can also find a compliance matrix, teaming partners, incumbent point of contacts, expiring contracts, and proposal templates. Discover, manage, and secure government contracts with BidSpeed. BidSpeed is an official partner of the Small Business Administration ETG Empowered to Grow program. Contact BidSpeed today. If you're thinking about competing for contracts with the Department of Defense, you need to prepare for CMMC. That's the Cybersecurity Maturity Model Certification. C3's suite of CMMC solutions include C3 Command, C3 Catalyst, and C3 Core. These three solutions answer the needs of every defense contractor. Whether your CMMC priority is a fast, defined path to compliance, or you need the flexibility to manage multiple environments, C3 offers solutions. They are your partner with a deep expertise in IT, cybersecurity, and compliance. Contact C3 today. WorkPlan. WorkPlan is an online contract management and accounting tool designed for federal contractors and hosted by Amazon Web Services. Get and stay DCAA compliant, manage expenses, timekeeping, and forecasting, plus use the WorkPlan platform to manage your capture process and your CRM. Customers can integrate their HR and payroll into this one easy-to-use solution. Contact WorkPlan today. Ateria. Ateria specializes in Microsoft Cloud licenses and services for government and government contractors. Ateria provides a business advantage for Microsoft Government Cloud licensing, managed IT administration and security, as well as data intelligence services and solutions. They implement secure, compliant, and scalable solutions to enhance operations, reduce risk, and uncover opportunities. Contact Ateria for expert IT assistance. Okay, last but not least, we want to thank our friends over at Gov White Papers. Gov White Papers is the central hub for government and supporting industry, government contractors to find and post content geared towards solving public sector challenges. With your free membership, you can add relevant white papers, case studies, data sheets, and more, making your content available to a wider government audience. Have the expertise but not the content? Gov White Papers can also create materials to meet your specific needs. Join for free today at govwhitepapers.com. Okay, the reason we are here today is to cover the DFARS Part 216. We've got two lovely ladies, and I took a peek at their slides. They look great. Looks like some good content, and I'm going to turn the floor over to them now. Karen, thank you so much for joining us, and look forward to your presentation, and the floor is all yours.
Great, thank you, Jennifer, and we're excited to discuss the DFARS Part 216, types of contracts. And just a little bit about myself. Again, my name is Karen Harbaugh, and I'm a partner in the DC office of Squire Patton Boggs, and I specialize in government contracts and national security matters for my clients. Squire Patton Boggs is a full-service global law firm, and so we do have offices in DC, but we have across the U.S. and the globe, we have 40-plus offices in 4 continents, and we have over 1,500 specialist practicing lawyers. So if you have a legal need, there's an area that we cover. We provide insight at the point where law and business and government meet, and we give you a voice, support your ambitions, and achieve successful outcomes. So thank you for your time today. And Genevieve, please introduce yourself.
Thanks, Karen. Hi, everyone. My name is Genevieve Hubbard. I am an associate that works in the DC office of Squire Patton Boggs, primarily in its public policy and government contracts practice groups. And I am so happy to be with you all today and presenting with my colleague, Karen. Before we begin, I do just want to note that the opinions expressed in today's webinar are those of the presenters, Karen and I, and do not necessarily reflect the views of our firm, its clients, or any of their respective affiliates. This presentation is for general information purposes and is not intended to be and should not be taken as legal advice. So with that, I will kick off today's presentation. Jennifer, you can move to the next slide, please. Okay, so great. Just to back up and give a really big picture overview to set the stage for our presentation today. Starting with the Federal Acquisition Regulation, or FAR. The FAR is the primary set of rules and regulations regarding government procurement in the United States, as you all probably know. It is used by all government agencies in their acquisition of supplies and services with appropriated funds. The DFARS, the Defense Federal Acquisition Regulation Supplement, provides acquisition policies and procedures specifically for the Department of Defense, or DoD, as I'll probably say in this presentation. DFARS Part 216 in particular provides guidance on contract types specific to DoD procurements. And so that is the portion of the DFARS that is the topic of our presentation webinar today. DFARS Part 216 implements and supplements FAR Part 16. So the FAR and the DFARS are complementary documents. FAR Part 16 describes types of contracts that may be used in regular acquisitions and provides a framework for selecting the appropriate contract type based on the specifics of the procurement at issue. DFARS Part 216, on the other hand, builds upon FAR Part 16 and provides more specific, nuanced regulations that apply to the Department of Defense. The structures of the DFAR and the FAR mirror each other. So FAR Parts 1 through 52 are supplemented or modified by the DFARS Parts 201 to 252. So this is all to say that you really need to reference the FAR as well when looking at DFARS Part 216 and read them in conjunction with one another so you can get a full picture of the rules and regulations that might apply. There's also a third piece I want to mention, and that is the DFARS Procedures, Guidance, and Information, the PGI. The PGI outlines procedures for selecting the appropriate research and development contract type. So that's another resource to reference for those specific types of contracts for research and development contracts. So in sum, it's the DFAR, the FAR, and the PGI read together. Those three items provide the full spectrum, the full universe of rules and regulations needed when you're looking for guidance for DoD contracts. Next slide. There are many different types of contracts, as you can imagine, that DoD and its components issue, and we will be talking about the main ones today. Those include here listed fixed price contracts, cost reimbursement contracts, incentive contracts, indefinite delivery or IDIQ contracts, time and materials, labor hour, and letter contracts. And we will discuss each of them briefly in today's webinar. Next slide. So this is a chart we thought would be helpful to show just to give you some context for what we're saying and how it all applies in real life. It's a graphic of both competed and not competed contract types that DoD rewards most often. So you can see a fixed price is the most common, with cost type contracts in second place. And those two together account for the vast majority of awarded DoD contracts. The other types, including time and materials and labor hour contracts and others, are used less often or account for a much smaller percentage of DoD awarded contracts. Next slide. Just a little bit more introductory before we get into our contract types. Again, a wide selection of contract types are available to the government and contractors. And the reason for this is really to provide flexibility to the government in acquiring the large variety and volume of supplies and services that are required by federal agencies. And in this case, it's largest federal agency, the Department of Defense. One caveat for DoD contracts: the use of any cost reimbursement line item for the acquisition of production of major defense acquisition programs is generally prohibited per the 2013 National Defense Authorization Act. Contracting officers are the ones that are responsible primarily for selecting and negotiating the most appropriate contract type. And so when they're picking the contract type, they'll think about how best to determine how best to mitigate risk inherent in any type of contract that the Department of Defense engages in. Next slide. Okay, so getting into our first contract type, which is fixed price contracts. Fixed price contracts are, as they sound, contract vehicles that establish fixed prices for a contractor's product or service. A contractor in this case bears the risk of any increased cost of performance, but they also benefit from the lowest performance cost. A variation of the fixed price contract for DoD contracts is the fixed price contract with economic price adjustment. And it is what it sounds like. It's a fixed price contract, but it provides for some upward and downward revision of the stated contract price upon the occurrence of certain specified contingencies. And those might be established changes in established price of items, changes in the specified costs of labor or material, or changes in the cost of labor or material standards or indexes, which would be identified in the contract itself. Next slide. There are some limitations to when economic price adjustment provisions can be used. For example, they may only be used when the total contract price exceeds the simplified acquisition threshold, which is currently set to increase from $250,000 to $350,000 later this year, and may only be used when delivery or performance will not be completed within 6 months after contract award. The DFARS recognizes that this kind of provision, economic price adjustment, can cause significant and unanticipated price increases. So for that reason, it dictates to contracting officers that they should only use these types of provisions when general economic factors make the estimating of future costs too unpredictable within a fixed price contract. The primary factors that contracting officers must consider before using economic price adjustment provisions include the volatility of labor and or material costs and contract length as detailed in the PGI. And just note that the PGI also provides guidelines for any adjustments based on cost indexes of labor or material, so you can refer to those guidelines. Okay, next slide, and Karen, over to you to talk about cost reimbursement contracts.
Thank you, Genevieve. So continuing on, now that we've closed out the discussion of fixed price contracts, moving on to the next type of contract, which is cost reimbursement contracts. And so with respect to a cost reimbursement contract, it provides for the payment of allowable costs incurred to the extent that it's prescribed in the actual contract itself. And within this type of contract, it needs to establish an estimate of total costs for purposes of obligating funds. And this type of contract also needs to establish a ceiling that the contractor may not exceed without the approval of the contracting officer. And this is a way for the government to limit its obligation. But on the flip side, it also allows for the contractor not to be obligated to continue work beyond the funding ceiling. And in these types of contracts, there is typically a clause that requires the contractor to give notice to the government when it's going to be at a certain percentage of sort of what I would call cost burn. So that way the government is aware. It could be, 75, 85%, where you would need to let the government know, in particular the contracting officer, so they can understand where you are in performance vis-a-vis the amount of cost that you've incurred. Next slide. So continuing on cost reimbursement contracts. So when can they be used? So they're used when the agency is not able to define its requirements sufficiently to allow for a fixed price type contract, or there's uncertainties in the contract performance that, again, doesn't permit cost to be estimated with sufficient accuracy to use any type of fixed price contract. So you can see what the theme is. The government is definitely pushing in leaning towards fixed price contracts. And, as Genevieve had shown in an earlier slide, that's where DoD typically goes, is, with fixed price contracts. But there are times when, because of, you're not allowed, you don't know the requirements or the costs are uncertain, that a fixed price contract is not feasible, and then you would go with a cost reimbursable contract. So there are some limitations on the use of certain types of cost reimbursement contracts. And so one of the limitations is that the contracting officers may not use a cost plus fixed fee, award fee, or incentive fee when there is a military construction or military family housing projects. There's also other limitations. In particular, a cost reimbursement contract can only be used if the contractor's accounting system is adequate for determining costs applicable to the contract or order. And then additionally, prior to the award of a contractor order, the government needs to have adequate resources available to not only award a cost reimbursement contract, but also manage that contract. Because with a cost reimbursable contract, there needs to be appropriate government surveillance, supervision during performance to provide reasonable assurances that there's efficient methods and effective cost controls in place in order to have this type of contract. Next slide. So continuing on, we're going to drill down a little bit on the types of cost reimbursement contracts. The first one we're going to discuss right now is the cost plus fixed fee contract. So what is that type of contract? So it provides for a payment to the contractor of a negotiated fee that's fixed at the inception of the contract. So this fee does not vary, and it shouldn't vary based on any variance in the actual cost. However, it can be adjusted as a result of changes in the work to be performed. In this type of cost reimbursement contract is typically used for the performance of sort of research, R&D, preliminary exploration or study that might be done, where that level of effort, the LOE is not known. And it can also be used in development and testing contract as well. So in addition to, some of the other general limitations I talked about in the previous slide, a cost plus fixed fee contract cannot be used for contracts that are funded by a Military Construction Appropriations Act that are estimated to exceed $25,000 and will be performed within the US except Alaska. But there is a process to get pre-approval for funding this type of military construction contract. And in those cases, the secretaries of the military departments are authorized to approve such contracts that are for environmental work only, and provided that the environmental work is not classified as construction. Additionally, the SecDef, or Secretary of Defense or designee, must approve such contracts that are not for environmental work only or are for environmental work classified as construction. And one other note on another limitation is that the use of cost reimbursement contracts is prohibited for the acquisition of commercial products and commercial services. And that is, per FAR Parts 2 and 12. Okay, next slide. So moving from cost reimbursement contracts, we're going to talk next about incentive contracts. So an incentive contract, as you can probably glean from the title of it, it's designed to motivate the contractor to achieve, specific acquisition objectives. And so in this way, they, in the contract, there's this establishment of reasonable and attainable targets. And with that, also incentives to motivate the contractor. And the types of performance incentives relate to areas of milestones like delivery or test schedules, QCs, quality controls, maintenance requirements, and reliability standards. There's in the PGI 216.402-2, it goes into sort of the defining the specifics of the types of milestones and test delivery schedules that might be part of performance incentives. So please refer to that PGI as well as the DFARS. Next slide. So one type of incentive contract is a fixed price incentive / firm target contracts. And in this type of contract, there is a target cost, a target profit, a price ceiling, and a price adjustment or profit adjustment formula. So the contracting officer will, does give particular consideration to their use of these types of contract, especially for acquisitions moving from development, so the development stage to actual production stage. This type of contract is not mandatory for initial production, but the contracting officer should evaluate it for each acquisition situation. And in particular, a contracting officer, is required to pay particular attention to share lines and ceiling price for these types of incentive contracts, with the 120% ceiling and a 50-50 share ratio as sort of the point of departure for establishing the incentive arrangement. In the PGI, and there's a reference to it, the PGI 216.403-1, there is, in that section, it refers to the contract pricing reference guide. And in that guide, it details the considerations involved in selecting the proper contract type. For example, it is not in the government's best interest to use a fixed price incentive contract when that cost risk is so great that establishing a ceiling price is unrealistic. Another consideration on why it would not be in the government's best interest to use a firm fixed price incentive contract would be on production programs until costs have become stable. Additionally, for example, for a sole source major systems procurement, contracting officers should not utilize a firm fixed price or fixed price incentive contract. Should utilize a firm fixed price incentive contract instead of just a straight firm fixed price contract, unless the reasons for the significant variation are well understood and actions have been taken to ensure significant variations will not reoccur. So again, check the PGI, because there is a step-by-step process for analyzing and calculating the risk with this type of contract. Next slide. So the other type of incentive contract is a cost plus award fee contracts, and maybe some of the audience have been involved in these types of contracts, but just give you a little high level information on it. It provides for a fee of a base amount fixed at the contract inception, and then an award amount that the contractor may earn in whole or in part during performance sufficient to provide motivation and cost schedule and technical performance. So if the fee determining official has determined that the contractor performance has been submarginal or unsatisfactory, the award fee is normally not earned. In a cost plus award fee contract, it is suitable for the level of effort contracts where the mission feasibility is established, but the measurement of achievement must be by a subjective evaluation rather than objective measurement. And contracting activities in these types of contracts may establish a board to evaluate the contractor's performance and determine the amount of the award, or recommend an amount to the contracting officer. And so the contracting activity may also afford the contractor the opportunity to present information on its own behalf. So, one advice or recommendation would be, if a contractor has the opportunity to present information as to why they should get the award fee, definitely take that opportunity to provide a response. Next slide. A little bit more specifics on the cost plus award fee contracts. There is a concept called award fee pool, and this is the total available award fee for each evaluation period for the life of the contract. So the contracting officer is required to say basically 40% of the award fee that's available for the final evaluation period. And the reason that this is done is to motivate the contractor's performance. And then the at least 40, say for the end, and then the rest is supposed to be distributed over the evaluation periods. And then that is, again, a reason to incentivize the contractor to have, excellent performance throughout the life of the contract. With the award fee evaluation and payments, so you have the pool, and then of course the contractor is seeking the full award fee and getting paid on that. So award fee payments, other than payments that are resulting from the evaluation at the end of an award fee period, are prohibited. So final payment needs to be consistent with the final valuation of the contractor's overall performance against the outcomes specified in the award fee plan. Next slide, and I'm turning it back over to Genevieve.
Thanks, Karen. Yes, I'm going to move now on to discuss another contract type, indefinite delivery contracts. Within that category, there are 3 different types of indefinite delivery contracts. Those are definite quantity contracts, requirements contracts, and indefinite quantity contracts. Generally, these categories are used to acquire supplies and or services when exact times or quantities of future deliveries are not known at the time of the award. Next slide. So indefinite quantity contracts, these provide for an indefinite quantity, as Karen and I keep saying, as it seems in the name of the contract, of supplies or services during a fixed period, but within some stated limits. So the contract must require the government to order and the contractor to furnish a stated minimum quantity. And if ordered, the contractor must furnish any additional quantities, but not to exceed the stated maximum. So there are some boundaries there to protect the government and the contractor. And the government places orders for individual requirements under this contract type, under indefinite quantity contracts. You may hear the term of art indefinite delivery, indefinite quantity, IDIQ contracts. So these are, as I was just saying, typically used for recurring DoD needs. So the IDIQ is awarded, and then the government places delivery or task orders for individual requirements under that IDIQ contract. And just to give you an example so you can understand how this works if you haven't worked on an IDIQ contract before. Right now, actually last fall, DLA, the Defense Logistics Agency, awarded 85 companies positions on a potential 10-year, $11.9 billion JETS 2.0 contract, the J6 Enterprise Technology Services 2.0 contract. And this contract is to provide for information technology support to DLA and other DoD components. DLA did this through an IDIQ contract. So they reportedly received 259 offers through a competitive acquisition process for the IDIQ. And then out of those 259, 85 companies received the award. So how it works is then DLA obligates defense working capital funds upon the award of task orders under the IDIQ. So essentially the awardees have won the right to compete for the task orders issued under the IDIQ. So winning the IDIQ is no guarantee of work, but that means that you're now in the pool to compete. Next slide. A few more items just to note on indefinite quantity contracts. Contracting officers must give preference to making multiple awards of indefinite quantity contracts under a single solicitation for the same or similar supplies or services to 2 or more sources. There are some exceptions to that rule, including that no task or delivery order contract in an amount estimated to exceed $100 million, including options, may be awarded to a single source unless certain conditions exist. To get around this limitation, the heads of agencies must determine in writing that these certain conditions do exist, including that the task or delivery orders are so integrally related that only a single source could perform that work. The contract must provide only for firm fixed price task or delivery orders for certain products or services if you want to get around this limitation. And only once, and the government must show that only one source is really qualified and capable of performing the work and at a reasonable price to the government, or that it is necessary it's in the public interest to award the contract to a single source due to some exceptional circumstances. So that just gives you an idea of the factors that are needed to be met in order to overcome the rule on limitations that I just discussed. Next slide. A little bit more on indefinite quantity contracts. The senior procurement executive is the one with the authority to make the determination that an exception to the rule I just discussed is warranted. And when they do that, they must determine that the task or delivery orders expected under the contract are so integrally related that only a single source can efficiently perform the work instead of reasonably perform the work, which is required by the FARS. So it's a little bit of a higher bar that the senior procurement executive must overcome in order to warrant an exception to the rule for a single source. Next slide, and Karen, back to you to finish out with T&M, labor hour, and letter contracts.
Great, thank you, Genevieve. So to sort of wrap up the types of contracts, I'm going to first jump in and talk about time and material, or we use the acronym T&M, so I might use that interchangeably. And so so a T&M contract, it provides for the acquisition of supplies or services on the basis of your direct labor hours and your actual costs for materials. So for purposes of what is involved in the labor hour component or time component, this is a specified as fixed hourly rates based on, different labor categories. It could be, a project manager, an IT, programmer, help desk. And in this case, that fixed hourly rate needs to include all of the costs that are built up to charge the government. So that will include the wages that are paid to employees or consultants, your overhead costs, your general and administrative or G&A expenses, and of course profit. And then moving on to the actual cost for materials, actual cost for materials may only be used when it's not possible to estimate accurately the extent or duration of the work or to anticipate costs at the time of placing the order. So this would be an alternative in terms of a fixed price contract. So that's why, I guess it's fixed based on rates, but instead of not being able to accurately anticipate costs, you would do a T&M contract. And as in the earlier slide, the government, DoD does lean towards fixed price contracts versus T&M, but they do, in certain circumstances, do award time and material contracts. So further to a T&M contract, there's also a labor hour contract, which is a variation of a T&M. So the only difference there is that there's no materials that are being supplied by the contractor. And with respect to the T&M, and we see this in contracts that they're, with this fixed hourly rates, there might be and should be escalations on the hourly rates. And so what companies will do is provide for option years, there might be an escalation in the hourly rates, for cost of living and, and inflation and that sort of thing. So you might see where it is fixed hourly rate, there might be escalation in, from the base to the option years. Next slide. So with respect to a time and materials and labor hour contracts, so what are the limitations in order, to use this? So in order to use a labor hour, time and material labor hour contract, the contracting officer must demonstrate that no other contract type is suitable. And so we talked about it earlier. To the extent that the extent and duration of the work or anticipated costs are not possible to estimate at the time, then the T&M contract would be appropriate. And with respect to a time and material or labor hour contract, they can only have a base plus option periods that are 3 years or less. And additionally, for contracts or orders where the time and material labor hour exceeds $1 million, than the senior contracting official must approve. So that's a few layers above the contracting officer. With respect to contracts that are equal to or less than $1 million, then the approval for these types of contracts would only have to be approved one level above the contracting officer. Next slide. So we touched on T&M and labor hour. Now we're going to go into discussing letter contracts. So what are these? They are just preliminary contractual instrument document that authorizes the contractor to begin immediately manufacturing supplies or performing services. And so this is basically, you know, an authorization to proceed, getting the contractor started so they're not working at risk. But with this type of letter contract, as part of that letter contract, there must be certain terms in there that are required, and it makes sense because you don't want the letter contract to go forever without the terms being definitized in the contract. So in the actual letter contract, there needs to be a schedule that sets forth that by the earlier of either 180 days from the contractor, after the contractor submits a qualifying proposal, or the date on which the amount of funds obligated on the contract action is equal to or more than 50% of the not to exceed price that's in the letter contract, that there has to be, that they have to ink the final contract. And I wanted to note that submission of a qualifying proposal, it needs to be in accordance with the definitized schedule, that because it is considered a material element of the contract. So further details are set forth in DFARS 217.7404-3. So it's important to refer to that, especially if you're in a stage where the government needs a contractor to start performance, but everything has not been definitized yet. But you want to make sure that you have, there's protections in place with respect to a letter contract. Next slide. So moving on from T&M, labor hour, and letter contracts, to subpart 216.7 covers other types of agreements. And in this case, it refers specifically in this section to basic ordering agreements, or BOAs. And what these are again, a written instrument of understanding that's negotiated between the agency, the contracting activity, or the contracting officer, and the contractor. And so what is contained within a BOA? So these are basically terms and clauses applying to future orders / contracts between the parties during its term. And it'll have a description, and be as specific as practical of the supplies or services to be provided. And it also sets forth the method for pricing, issuing, and delivering future orders under the BOA itself. Next slide. And this is our final slide. Continuing on discussing BOAs. So BOAs are not contracts. They're just risk. As I talked about earlier, written instruments of understanding between the parties, between the government and the contractor. And what these are used to expedite contracting for uncertain requirements for supplies or services when specific items, quantities, and prices are not known at the time the agreement is executed, but a substantial number of the requirements for the type of supplies or services are covered by the agreement that they believe are anticipated to be purchased from the contractor. And this can result in economies in ordering parts for equipment to support by reducing sort of administrative lead times, inventory investment, and inventory obsolescence due to design changes. And one restriction on orders being placed against the BOA, they may not exceed 5 years. So this wraps up our discussion of DFARS Part 216 on types of contracts. And, we thank you so much for attending the webinar today. As you can see, there are many different contracting methods, and today we just touched on them very high level. But please feel free to reach out to us, Genevieve and myself, with any specific questions about a particular contract type or any other government contracting needs that you have.
Karen and Genevieve, you guys are a dynamic duo. This was a great presentation, very clear, concise, easy to understand. So I thank you for all the time that you took to put together the slides and then the time that you shared with us today. Everyone, as Karen said, if you have questions about anything that they covered today, you've got Karen's contact information here and Genevieve's as well in the earlier slides. Both ladies, I believe, are on LinkedIn, so feel free to reach out to them there as well. We can also patch you through if you have any trouble. And if anyone is watching the recording on YouTube, just give us a like, leave a comment. We would love to hear from you. And for anyone that is here with us live, we should have this recording up within 24 hours. And we thank you, and we will continue in the series on Friday with DFARS Part 217. We are going sequentially through the list. So we hope that you'll join us again on Friday. And thanks again, Karen and Genevieve. Any last words?
No, just thank you so much.
Yeah, thank you so much.
Okay, thank you, ladies.